Page number 7, number 21 to 25.
Serial number 21 for petitioner. You have to wait. It's for admission stays there. You wait. Next. This what do you want? Post family. They're not counsel for the petitioner seeks time release after vacation.
Page number 8, number 26 to 31.
Serial number 26 released tomorrow at request of petitioner. Would be.
Most petition was filed before starting.
Right?
Being more than responded.
So initially when you filed in Karkala, that time you are residing in Karkala.
Was residing at Karnataka.
Where? While residing at Matrimonial House, you filed section 13 along with the husband.
She stayed there. She had to go out for this reason. She had to be because cost ID shows not the address. Cost ID. Reason why he had filed it there not was because she was selling it. It's what I want.
The address is the same. The address is the same in both the petitions.
Address is the same.
Right, but obviously then she would not have resided in Karkala. What you are submitting is wrong.
What I was told.
He may say something, at least you should verify before you make submission to the court. Submission is wrong. The address shown is Udupi. The divorce petition is filed when she was in Udupi. The 125 is filed when she was in Udupi. You are entitled to file that. ಅವ್ರು ಏನಾರ ಬಂದು ಹೇಳ್ತಾರ್ರಿ ಕ್ಲೈಂಟ್ ನೀವು ಸ್ವಲ್ಪ ವೆರಿಫೈ ಮಾಡ್ಬೇಕಾ ಇಲ್ಲ. So he has taken notice in this 125 proceedings.
Yeah.
Notice to respondent along with regular service of notice. Counsel for the petitioner is also permitted to take out notice with counsel appearing for the respondent for the senior civil judge at Karkala or at the principal family court Udupi. That is on IA1 of 22. There shall be stay of all further proceedings in MC 51 of 2020, depending on the file of senior civil judge and ACJ in Karkala. The next date of hearing.
Lord.
This both parties granting 6,800 and 4,000. Meanwhile, the started training since the senior civil assets matters. She's alone. We do score days. Not getting from our phone. And it's not.
Agitendri, you said the order is passed.
No, not in hard first. Spending. Profile. And but
You already filed execution. For what?
recovery of previous days.
The order ಆಗಿದ್ಮೇಲೆ ತಾನೇ execution ಹಾಕೋದು. What is the order? Why did you file that 125 proceedings? ಎಲ್ಲದು ಅದು Bangalore ಅಲ್ಲಿ. At Bangalore.
For the intentional petition.
Counsel for the petition corresponding. Along with regular service of notice, the counsel for the petitioner is permitted to take out notice to the counsel representing the respondent court, family court at Bangalore. So no petition is pending in Gubbay Tumkur.
No. Let's say 167, so on, so it's pending before the intentional seat in Bangalore. But this court, so, okay,
Orders on stay. All further proceedings in MC 167 of 2020 and execution 28 of 2022 on the file of learned 8th Additional District and Sessions Judge, Bangalore. Bangalore Rural District, the next date of hearing. Granted stay. Jan. From Bangalore for which court? Where have you stated? Read it. Just read your prayers. Jay? Where is it? Where is Madikeri? Where is Madikeri in your petition? I know Madikeri is in Kodagu. Huh? Typographical. Prayer and liberty, senior civil judge, CJM and Relly, Yavu. Haryana, and send it to Haryana. Then, where is Madikeri in it? Office nodal idnala. Huh? Delhi. Correctly in prayer. This is your sound. Your volume is only that much. So you increase volume one slowly. Be louder so that I can understand.
She's not working on
So you have filed a petition for what? Husband is filed for? All right, you carry out the correction. Right now, third learned counsel for the petitioner. Issue notice to stay in a Bardilwala ನೀವು application allu bardilla. Even in your stay application, you are not mentioned. In the affidavit, issue notice to respondent along with regular service of notice. Counsel for the petitioners shall serve a copy. It's also permitted to serve a copy of this petition to the counsel representing the respondent for the family court at Bangalore or for the senior civil judge and CJM Kodagu. Orders on IA. There shall be stay of all for the proceedings in MC 369 of 2023 on the file of third additional principal family judge Bangalore. Stop. In Munche, a learned counsel for the petitioner is permitted to carry out the corrections, incorporating the correct name of the court in the prayer para and also in the IA. We shall do during the course of the day. Carry out now. Yes, Siddaramaiah. Given madre, from when you are practicing, 6 months. You're comfortable in English or Kannada? Kannadadalli ಹೇಳಿ. ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು ಪೆಟಿಷನ್? ಅವ್ರು ಏನಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ? ವೈಫ್ ಹಾಕಿದ್ರು. ಹಸ್ಬೆಂಡ್ ಏನಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ? ಡೈವೋರ್ಸ್ ಪೆಟಿಷನ್. ವೈ ಇಟ್ ಶುಡ್ ಬಿ ಟ್ರಾನ್ಸ್ಫರ್? ಏನಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬೇಕು? ಎಷ್ಟು? ಹೋಗಿ ಹೇಳಿ ಹೋಗ್ತಾರಲ್ಲ. ಏನ್ ಕಷ್ಟ? So what is the law on transfer under section 24? Where it should be transferred? Because the ladies, it should be transferred. Okay. What are the requirements? ಹೇಳಿ, ನಿಮ್ಗೆ ಗೊತ್ತಿರೋದೇನು ಹೇಳಿ. ಗೊತ್ತಿಲ್ಲ. ಕನ್ವೀನಿಯನ್ಸ್ ಇರ್ಬೇಕಲ್ವಾ? ಲೇಡಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಹಾರ್ಡ್ಶಿಪ್ ಕಾಸ್ ಆಗುತ್ತೆ ಅವ್ರಿಗೆ. ಮಕ್ಕಳಿದಾರ? Counsel for the petitioner issue notice to respondent along with regular service of notice. The petitioner shall serve a copy of this petition. The counsel representing the respondent for the family court at Bangalore or at Davangere or at the family court Davangere. What else you want? Here in big stay. Orders on IA 2 of 23. There shall be stay of further proceedings in MC 6535 of 2020. Pending on the file of 5th Additional Principal Judge Family Court at Bangalore till next date of hearing. Kannadadallೇ ಮಾಡ್ಬೇಕ್ರಿ. Don't worry, you have to argue. English ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ you start in Kannada.
Why, please, my lords, I appear for the petitioner, my lords. Petitioner is the wife, my lords. The husband has filed the annulment petition, my lords, which is pending consideration before the family court at Bengaluru. And the wife is residing in Malavalli. He is finding it difficult to travel 108 kilometers. Therefore, I have filed the present petition.
You are seeking transfer from Bangalore to Malavalli.
Malavalli, please, my lords.
Petition is filed at Bangalore by the husband.
Husband, please, my lords, for annulment.
What have you filed?
I have not filed any petition.
Same author. There shall be stay of further proceedings in MC 2463 of 2019. Pending on the file of both additional judge family court at Bangalore till next date of hearing.
That's one request, my lords. Let this stay not come in the way of payment of maintenance. My lord. There is a maintenance ordered.
Sorry?
The stay, my lords, let it not come in the way of payment of maintenance, my lord. There is already a maintenance order, which my lords would find it at page 46, my lords. Let that not be stated. One observation, if your lordships could make, otherwise they may take that benefit, my lords.
However, this order of stay on the proceedings shall not come in the way of the respondent husband making payment towards of maintenance and litigation expense.
I am grateful.
And so also the petitioner initiating proceedings for recovery of this.
I am grateful.
Yes. Bangalore to Madikeri. Hardly one. But by 40-50 kilometers. 140. Same order. There shall be stayed for the proceedings in OS number 2 of 2023 on the file of First Additional Principal Family Court, Mangaluru, Dakshina Kannada District, in next date of hearing. Yes, what is this calendar of events? You're not permitted to write the exam, right? No, why you are not permitted? Why they were not permitted?
They not issued the article.
Why? No, why?
It was not there. Subsequently, they granted the
So where is the approval for them?
approval for them, sir.
Where is it? For these two students.
It's there.
So they were not included in the earlier petition.
That is, they were not.
What are the names?
Who are, last page, my lord.
You filed this. You filed this here.
That's not my hand.
Political memo. So same order
Same order.
of annexure H. When is the exam?
Yes,
Today.
yes, sorry.
Then they will miss the exam today. Who appears? Who's appeared in the Girish is here? Girish will take notice for R1. So, hopefully, Learned Counsel for the petitioner. You're appearing on behalf of Girish. You take notice for R1. Learned Counsel for the respondent university, namely Sri Girish R. Kumar R. is present before the court and accepts notice for respondent number 1. Is contended by Learned Counsel for the petitioner that similarly placed petition students of the very same university, very same college, very same college had approached this court in writ petition number 7831 of 2023. And they were granted an interim order by this court on 11/4/2023. Stop. Really, annexure H is copies the same order from annexure H where I marked in red pen till the end of it. So this is coming up on, then this is adjourned sine die. Same order. Lecture H. Take notice. You already you file it with a memo. So take notice for this case also. Serve a copy on him. It's okay. The Girish Kumar and the present and the colleague of learned counsel Sri Girish Kumar is present before the court. Accepts notice for the university. Baki ella same out. Yes. Yes, madam. Serial number? All this with serial number 14. Yaru Para Fatima. Where is she?
Please, my lords.
And Para, you take notice.
Please, my lords.
Our learned counsel for the petitioner. Sure. Notice how our learned counsel Srimati Para Fatima, who's in the panel of the university, is present before the court, accepts notice for respondents 1 and 2. Call this matter along with serial number 14.
See that first?
Is this rectification? Either. The paid when? You are not given the envelope and the cover and acknowledgement. Huh? What is it? Acknowledgement. Kotilva. The council seeks a week's time. Same is granted. If needful is done, registry to issue notice to respondent. Your stay is not granted. You didn't argue earlier. You don't know what has happened in your case. Stay is granted or not granted? You want extension of stay? Stay granted earlier is extended till next date of hearing.
Okay.
There's no representation on behalf of petitioner. However, this petition is filed under section 24 of Code of Civil Procedure, seeking transfer of the proceedings initiated in criminal miscellaneous number 179 of 2023. Is pending on the file of Principal Judge Family Court at Mysore. Full stop. The said proceedings is initiated and Section 125 of the Code of Criminal Procedure. Under the circumstances, the present petition would not be maintainable. It's not maintainable, as the petitioner would have to approach the appropriate forum in the relevant provisions of law seeking transfer of the matter initiated under the Code of Criminal Procedure. Hence, reserving liberty the petitioner to file appropriate petition. This petition is disposed of. For statistical petition, this petition stands disposed.
Number 11, Shivarudra.
Devrudra.
The petition, Lord.
Averi,
Lord,
you were not here last time. Now, what do you say? Have you gone through?
I am unable to hear my friend, Lord.
Michael Edra, he is sitting about, I don't know how many kilometers away and where. So you have to speak on the mic for him to hear you.
Is there is to consider for 21 and we are in the there for approval cannot be. We also have this that we are not in. Yes.
The petition, Delhi. Para 21 itself says to may be permitted to make admission. Para 21. This is prayer. With the examination fee, appear forthcoming examination, whether he was permitted.
Please, as permitted.
No, whether any order is granted. But which is the appeal file? Merits. Who has granted the interim order? When? Date. 10/11. 9? Date the order. You are present when the order was passed. Yes, Mr. Shivarudra,
Please, Lord.
repeatedly you don't have permission. Even according to and also
May make my submission, Lord.
yes,
If you're my lords are pleased, the order granted by the complete file is not there with me. The gist I'm remembering, Lord, which I could appreciate, my lords. The order which was not given to me only because of the reason that the government has not given the permission to me. Government gave me the permission only after me filing a contempt, and contempt Annex G kindly be seen, Lord. After filing the contempt petition, Lord, I was extended the permission by the government. I made the submission to the Pharmacy Council of India, submitting that the government has granted the permission. Please grant us the because the affiliating body is the university, and the permission which was to be granted by the government was delayed for the best reasons known to the government for more than 2 years. The admissions were made, and my approach this honorable court requesting all these things made, and I have brought out to the notice of the court also that after having the contempt filed and the contempt petition only, they have granted the permission, and I was not late in making anything before the second respondent. The second respondent, after considering the government order, has extended the permission from the next academic year. My lords may kindly see the letters which I have given with there. The extension was granted by the second respondent from second year onwards, from third year onwards, some fourth year onwards. Like when I was there before your lordship on the last occasion, where
already you may have been granted for the future years. Admittedly,
please,
you are not.
Please, my lord. For a moment, my lords may bear with me for a moment. The permissions which were granted throughout India for other institutions, which my lords were pleased to see on the other day, where it was granted from second year onwards, third year onwards, and fourth year onwards. Like, even if the second respondent grant me the permission from the second year onwards also, I'll be pleased. The
how they can grant you retrospective when they have already rejected?
That by my learned friend has to say, because your lordship kindly have a glance at the recommendations made by the second respondent before my lords on the other day, which I read out to my lords also. It is there in the files if your lordship certainly see him, Lord.
Where is it in the file?
It is in the file, Lord. He is in the file, and I have filed a IA also.
Which
Lord, IA is filed on.
IA.
One IA, along with one IA is also filed, Lord. That IA, I don't think my lords, they have put up the IA, but
there is for direction in that you have filed.
Kindly have a glance at it, Lord. Annexure P series ಅಂತ ಒಂದು ಹಾಕಿದ್ದಾರೆ. ಅದರಲ್ಲಿ I have brought out.
What have you filed?
But there is permissions which were granted by the second respondent to a number of institutions from second year, from third year, from fourth year.
All right, they have granted to the other institutions, but
please, Lord, I am also placed in the same situation where they can grant me the permission for our second year or onwards also, where the government order has been extended from that day onwards, where our students
about is given to. Sir, different misters.
No, Lord. No, I did tell Mr. Haveri. This is what has happened when once we were discussing about these things when I was at Bangalore.
I can argue. I think for your luck, you have been granted an interim order.
Please. ಅಲ್ಲ ಇಲ್ಲಿ ನಾನು ಹಾವೇರಿ ಅವ್ರಿಗೂ ಇದು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ದೆ ನೋಡಿ ಈ ತರ ಮಾಡಿದ್ದಾರೆ ನಮಗೂ ಇದು ಕೊಡಬಹುದಿತ್ತಲ್ಲ.
Haveri, I am not concerned about that. Now for your good luck or bad luck of Mr. Haveri, some interim order is granted by coordinate bench of this court. I don't know how, but if this court were to dismiss your writ petition, what is going to be the outcome of those students?
Certainly it will be at stake, my lord.
Yes, that is what you have to answer. How
it will be at stake.
What is going to benefit you? Normally I have been seeing students are taking interim order, completing the course.
Here, my lord, it is not the mistake of the petitioners, including the college. The college is also before my lord.
Admittedly, you don't have permission, sir, even according to you in your petition.
Please, my lord, please, for a moment, my lords, bear with me for a moment. The government order which was to be given by the government was delayed by 2 years. This I brought it to the notice of the second respondent, telling that everything was fine. The rejection in the first instance was made only on the ground that the government order is not there on that particular day.
All right, now you are before this court for declaration of results.
Please, Lord, please, Lord.
I'm not going to pass orders. You come back after your vacation. Let me not spoil your vacation. You come back and we will see. Or vacation rightly or whatever, there is some order. You have not filed vacating? Why? Ex parte order is granted. You should bring to the notice of the court by filing an application. How he is different from the other institution? Say so. No, you say whatever you want to say in your affidavit. Your filed statement. Your filed statement. Which para? 49.
I totally agree, not hear anything what Mr. Haveri wants.
So you have given approval for 22, 23. No, that you have given approval. No, no.
The proposal given to us, as to the petitions.
Oh, the approval is not, 1 minute. Approval is not given for 21, 22. 22, 23 you have given.
Oh, they haven't given, we made an application, online application.
So that is also not given.
No, 2020 they have given. That is there on the files, my lord.
But they required at all.
This is something misleading the court.
22, 23 fresh approval, you say that he has filed.
Yes, made an application.
Not given?
Nine sections are there.
Anyway, that is not the list before the court. All right, Mr. Shivrudra, you come back and you can address arguments.
Please, my lord.
That same order will hold good. Whether when is that order for you to take up the exam and results were withheld?
Results are withheld, results are not declared.
By which order?
Exams were permitted to be taken up, not exams were granted by this honorable court.
No, which is that order of withholding the result? Who appears?
There is no order of withholding the results, my lord. For a moment.
It's no order.
There's no order.
All right, you don't declare the result. It has to stop someday. All right, when do you want it? When are you coming back?
The third week of June, I'm back.
I'll relist this matter after 3rd week of June at request of Grand Council. For the petition.
My lords, I appear for the petitioner, my lords. My lords, I have filed an application here, my lords. I think that application is not put up. It was filed on 12th, my lords. 12th of April. If it's on the board, my lords, I'm only asking for announcement of results. In 2 writ petitions, my lords, I had filed application. Learned counsel, my lords, Mr. Sachin appears in the other matters. My lords.
Here before the court, your colleague is also here.
Please, my lords.
Now, the court has to appraise you who's present, who's not present in the court. You come on, see. One. What is the direction to announce results? What do you say? Notes ಮಾಡ್ತೀರಾ? Huh? December 2022 exam. First and second year. That is what you are seeking, Mr. Abhishek?
Yes, my lords. Undertaken pursuant to interim directions, my lords, passed by the honorable.
No, sir. Now, what is the grievance? What is the petition filed for?
My lords, it is for revaluation, my lords. Learned counsel also had said, now that they have gone into the new system, if the students who had appeared for examination passes in the examination, nothing further would survive. That is why, my lords, I filed an application for announcement of results.
All right, if your students pass, then it will not.
Nothing survives. Nothing survives.
To announce the results, how much time you will take? Within 2 weeks.
Direction may kindly be issued.
So I'll allow that application for direction.
Please, my lords.
Grant you 2 weeks. Third learned counsel Sri Abhishek Patil, Malik Patil for petition. I number 1 of 23 is taken up for consideration. This application is filed by the petitioners, seeking a direction to the respondent university to announce the results of the first and second year BSc Medical Imaging Technology examinations of December 2022, undertaken by the petitions. The present petition is filed for a prayer to conduct evaluation of the answer scripts. You are seeking third evaluation.
Yes, under the old rules. Under the 2012 rules, which are applicable.
Evaluation of the answer scripts under the 2012 rules. Full stop. Be that as it may, the present application is filed for declaration of results. The learned counsel representing respondent university submits that they will declare that on instructions he submits that they will declare the results within a period of 3 weeks from today.
My lords, supplementary exams are scheduled in 3 weeks. My lords. From 10 days, my lords, they have to announce the results so that we'll be prepared for the supplementary exams.
Within 2 weeks from today, in order to facilitate the petitioner to take up the supplementary exam.
Yes, my lords, if they have failed supplementary exams.
Accordingly, IA number 1 of 23 is allowed.
One other application is there, my lords, in one other petition.
20537.
Same application in all.
Different course, my lords.
Different course.
Different course.
Same order.
Same order, different course, my lords. Instead of first semester, it will be first year, my lords, in this first and second year.
Correct. Really, 20537. What you gave me earlier, madam, which was that? 11 otherly. 12.2 ಅಲ್ಲಿ ನೀವು order ಬರ್ಕೊಂಡಿದ್ದು. The next order is 20537. Same order in that it is for the first and second semester Bachelor of Hospital Administration in brackets BHA examination of December 2022. Similarly, others also like the same.
No, my lords, only 2 petitions, my lords. Only 2 petitions. In others, they have already announced the results. My lords.
So in others, there's no need of any order.
Yes, my
So
lords.
application is filed in only 20537 and 11412.
Yes, my lords.
Relist this matter after vacation.
Page number 30.
I'm seeking for a passover, my lords.
The petitioner, my lord.
My lords, on the last occasion, my lords had directed me to file objections to the memo for withdrawal. It's ready, my lords. I'll file it, my lords. So kindly pass it over.
But I filed an IA, that IA is not on board, I feel, my lord. The IA was filed on 11/4/2023 for declaring of the results.
It's not, my
The
lords.
Yes, so you have objections, madam.
Please, my lords, with respect
File
to,
it.
my lords, I would, please, my lords.
File
My
it.
lords,
We'll have
for submission, my lords, what I would request is, my lords, on the previous occasion, my lords, on the last year, my lords, similarly placed many of the institutions had approached this honorable court. That point of time, my lords, this honorable court had directed the university to constitute a committee, and then they let them submit the documents. The issue here is only with respect to admission approval, my lords. After the last date. So let them go submit their documents to show that they were within the date and everything, my lords. If that is sorted, then the petition may not survive. That will be easy, my lords. Rather, let them go to the university, my lords, and submit and approach the university and submit their documents. Then let there be a direction, my lords, to that effect.
you have students of which course?
My lords, they're all BSc nursing courses.
Is in nothing course, my lord.
So you have not submitted your documents, Mr. Shivrudra.
My lords, disputed, my lords,
This is,
Madam, let him submit.
one minute, Fatima, for him. But the problem here in this particular petitions, my lord, the affiliation granted by the university was withdrawn. That was under challenge before this honorable court. And this honorable court, after having dismissed the appeal, after 1 year or so, my lord, the affiliation was granted. There was no room for me to upload the names of the students who were there in our college. After having granted the approval, then only they came back, though the admissions were made in the earliest given point of time. This was made known to the university also. And after, in fact, my learned friend was very kind enough to instruct me to go to the university. My petitioners have gone. They have not accepted the papers unless and until there is a direction from this honorable court.
All right. So you have filed a memo for withdrawal.
My lords, that with respect to that memo, my lords, I have objections, my lords, because my lords.
I have not filed
Not Mr. Shivrudra, Mr. Suhas, Mr. Nishant has filed, my lords. With that last occasion, I had objected, my lordship had directed me to file objection. It is ready, my lords. That's the reason I sought for a pass.
My lord, your lordships were pleased last occasion, your lordships were pleased to ask me a question whether you sail in the same boat. I did say no. But that case was totally different than that of mine.
Madam, what is your objection for him to withdraw the petition?
My lords, the reason is, my lords, the conduct of the petitioners, my lords. They claim that they are the students and they produce the ID card, fee paid receipts, as well as the representation made by the college to the college principal. Whereas the college here, the college comes and submits before this court that yes, there are the students. We issue a notice. Outrightly, they say that they are not as students, my lords. It's a matter of perjury, and this.
Who says?
My lords, the college has told.
Yes, for the college. You're appearing for college? Not in the first court.
Kindly pass it over, my lords, with respect to that memo, my lords. I'll file my objection. It can be argued.
No, if that is not connected with, related with the other cases of.
My lords, with respect to the issue involved is with respect to the for non-approval of admission. But when it comes to the serial number 1, my lords, that is by the students who have approached this court with in total misrepresentation, my lords.
So we deal with that. Now, what about Mr. Shivrudra's case?
That may be de-linked, my lords. Let it be along with this, my lord. The issue involved totally with respect to other two will be the same. That's the reason I told let it be together. I will.
Some other day you file your statement.
Please, with respect to this, my lords, only with respect to Mr. Nishant's first matter, my lordship may pass it over, my lords. I'll file my memo and my lordship may take a record of it.
Okay. Learned counsel.
And one more submission, my lords, before.
Appearing in WP 3801 and other connected matters. Connected matters submits that the writ petition 3907 and 3908 are not connected and related to his petitions. Therefore, registry is directed to dealing. WP 3907, 3908, and 3909. They are not related.
No, my lords, the issue involved is the same, but it is a little different. That's all. My lord.
Already delink it, you can argue. Delink. What do you have to say in the Shurudra's case?
My lords, in Mr. Shivrudra's case, my lords, with respect to that particular, only if they come, if they let there be a committee, if there is a direction by this honorable court that the documents be verified, let them show the genuineness that these students were admitted within the last date of 2020-21. That point of
They have
time.
not gone and produced those documents, Mr. Shurudra.
Lord, they have not accepted it, Lord. We have gone. In fact, Para was kind enough to tell me, please go and approach, and they will do it.
No, let there be a direction by this court.
They did not accept it.
Let the respondent university constitute a committee, my lords, because on the last occasion, last year also there was issue, identical issue, wherein there was a committee constituted and the documents were verified.
Lord, one submission I want to make, Lord. On the last occasion, what these things happened on the last, that was totally different than this case. This is where the affiliation was withdrawn by the university, and that was challenged before this court. And for 2-3 years, the matter went on, and the appeal was dismissed. Then only it was granted permission. Your lordships were pleased to see that on the other day before granting the permission, my lords may recollect, my lord, on the last occasion, my lord, the petition I have shown one. That annexure I have not noted down. Where
in fact, last year also this issue was there, my lords, Mr.
Not about this college.
Not identical with respect to the different college, but the issue was same with respect to disaffiliation. And the committee was constituted, and they also appeared.
Not
specifically, it was for all the institution wherein the petitioner colleges therein who were in the identical footing also appeared, my lords. My lordship may direct all the matters in serial number 13, my lords, if the university constitutes a committee and let the inquiry with respect to the admissions, my lord, it will resolve the issue, my lords.
Yeah, I've already directed on the last date, asking you to go and submit your records.
Let there be a committee, my lords, because if there is a committee constituted.
What university, who are the members you want?
My lords, they have constituted with, they had members on the last occasion, like last year, my lords, let them constitute a committee. My lords, no, it's not the vice chancellor will not be a member, my lords, would be the other members.
The registrar evaluation trust.
No, my lords, the registrar administration, the registrar
Yes.
of the university, along with the other members of the university, my lordship may say, my lords.
How many members are there?
My lords, usually it will be around 5 members, or 3 or 5, my lords. It will be either.
All right, you registrar admin will be one of them, and then who are the other two members?
Few members of the universities, my lords.
Mr. Shurudra, you have not submitted the documents, or you have already?
Lord, they have not accepted. Lord, here the peculiar situation is, Lord, the affiliation of my institutions were only cancelled, which was withdrawn. That was under challenge before this honorable court. The writ was allowed. The the order was challenged in the appeal. Appeal was dismissed. After having dismissed the appeal, after 1 year of dismissing of the appeal, my lord, I was granted the permission. The admissions which were made, then, my lord, those students would not take up the examination. That was, I made the submission before my lords, and my lords were satisfied to grant the interim order on the last occasion, after having gone through the letter which was issued by the university, and the date. Your lordships were pleased to note that date, and then only the order was granted. Your lordships were very strict in granting the order also, after having heard the matter. On that day also, Lord, I was on the way.
To show that you have submitted these documents well within time.
Well, that's what has happened.
In this, para 1 minute, please. On this submission of documents, Lord, the portal was not opened for me because the institution was withdrawn. For that, I could not make a submission to the university. On the last occasion, my learned friend was pleased to say me, you please submit the documents, they may consider it. I did go to the university, I did submit the application. They said there's a court order, you come, otherwise we are not going to accept it. This is what has happened.
All right.
My lords, what happens is there are three options. If the portal is closed, they have the one more mandatory option is to send it by email, my lords. Email was not blocked as such. So the
What
only
is the
issue-
number of days given? What is the number of?
May make
Sorry,
my
my lords,
submission.
because
One
email as well as
submission.
the hard copies.
When
So
the
email is the-
affiliation itself is not there to the university from the university which is being withdrawn, will they accept in any way, in any
My
form,
lords,
will they
that
accept?
was the only issue. If they sent it by email, because nothing had stopped them to send the list of students admitted by them. Admittedly, there was no affiliation as on then case was pending with respect to withdrawal of
Students have
affiliation.
come back
Had
only
they
after they
sent
could
within
see.
the date, they would
Madam,
have.
if both of you speak together, what is this?
I'm sorry, my lords. Only request is
Subhadra.
let them go to the university
Madam.
lords, and submit, let them,
Subhadra.
and
Now whether affiliation is granted to you, permission is granted.
Please, no, please, it is granted. It is continued from retrospective, 1819 onwards. From the day it was
Madam, is
withdrawn.
there a scope now for him to submit the documents?
no, my lords, with respect to, he has to only show that the students, only if he satisfies the university, my lords, that they were
Students
admitted
were
at the
admitted.
time.
To the college.
That the college has admitted students within time. That's all we're looking for, my lords.
Direct pass an order.
Let there be a, my lords,
Yes,
let there be an order directing the university to look into the documents,
Verify the
verify
records and then.
whether the admissions were made within time or not, and subsequently take necessary orders with respect to the admissions, my lords, made by the petitioner college.
all right. Third learned council. Yes, you are in the other matter. You are not in Mr. Shirudra's case. Third learned council, Sri Shirudra. And learned council, Sri Karnataka of the respective university. The case of the petitioners that the petitioners given have sought for approval of admission for the first year BSc nursing course for academic year 2022-23. The further submitted by Learned Council for the petition that he has got the approval to permit to admit the students, but however, due to the inability of the students to upload the documents as the portal was not open, they were unable to submit the documents within time.
Not documents, my lords, their admission status, that they were admission.
Admission status to the university well within time. So by virtue of order dated 21/2/2023, this court passed an order permitting the petitioners herein to take up the first year BSc nursing course examination, which commenced on 22/2/2023. However, subject to the outcome of this writ petition, and the results were ordered not to be announced without leave of the court. Learned Counsel for the respondent university submits that it is for the petitioner to show before the university that they have submitted the
No, my lords,
required
that they were admitted within the last date.
They were admitted within the last date.
with regard to their admission before the cutoff date as stipulated by the university. Full stop. This order was passed on the previous date, directing the petitioner to produce all such necessary documents to show their admission was made before the cutoff date or the last date. Full stop. In view of the same, I deem it appropriate to constitute a committee consisting of 3 members, namely Registrar Admin, administration, and 2 other members of the university to verify and ascertain as to whether the petitioners were admitted to the college well within the time stipulated by the university.
Yes.
Report the same within how much time you would require, madam?
Let's, if they come and produce, maybe in 2 weeks, Millets, to constitute.
Yes, the report shall be filed within 2 weeks from the date of submission of the necessary documents by the petitioner college. When will you submit, Mr.
Tomorrow itself.
Millets, because it has to be before the committee, Millets, committee has to be constituted a week's time, and thereafter it may be done.
Not here, the results are already declared. Now the supplementary exams would commence if the students
No,
are.
results are not
June, July,
declared.
June, July, not soon, sir.
Results are not declared.
Results are not declared. Results are declared for the other students who are there, regular
Oh,
students.
I have passed an order that your results will not be declared.
Please, Lord, please. That's what I filed the IA for my lords to declare, requesting to declare the results like.
No, first of all, the committee has to be formally, they have to.
Please, Lord, please, 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 Lord.
He has
I
to
shall-
make up the members. The committee shall be formed within a week's time from today. And pursuant to which the petitioners shall appear before the committee and furnish the documents to show their admission and all other documents for having got admitted to the college well within the cutoff date. After the furnishing of the records and documents by the petitioner college, 2 weeks thereafter, the report shall be filed to this court by the committee. Is it all right, madam?
Please, Millets. Millets, similar order may be passed even Mr. Nishant's matter, except for the first,
You're also on the same lines.
same, please, with
The
respect. to
the next matter also, 3802, that is the next matter
Mr.
also.
Shivradra, in your both matter same order.
Please, Lord, please, oblige.
Millets,
Grateful.
same order may be passed in respect to the other connected matters too, Millets.
13.1, 13.27. Number 13373907 ಅದು ಈ ಲಿಂಕ್ ಆಗಿದೆ ಅಂತ ಮೂರು ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಏನು What about 3908 and 9?
Please, Millets, same order may be passed, Millets. 3908 and 3909.
Click on the mic so that she is aware that you are also talking. You are for the college. Yes. Have you?
Millets, I'm not able to hear them, Millets.
So whether they were admitted on time?
Millets, the contention is, Millets, outrightly, we had, I mean, the material and record shows that they were not admitted within time because the.
You also go before the committee and file
Please,
your
that's
record.
identical, I mean, order may be passed, Millets. I'm not able to hear, Millets, my learned friend Samush.
No, according to you, they were admitted on time. But already I have formulated a committee. Now go before them and you also deal with it. Again, they will come back, say the same thing.
Let's let the students as well as the college go because the petitioners are the students
And
here.
when college has given you reply, what's the difficulty for you to?
Please,
pass
please,
a-
please.
They have already given you a reply.
No, Millets, they have not. We have issued them a notice. They have not replied. It is an identical notice issued to all. None of them, except for the first petitioner, the first petition, none of them.
Means- And he's before the court, he's saying that you have issued him show cause notice.
Please.
Reply to it. Not reply.
Yes, let them, my lords, we had, in fact, let the same be order may be
To
passed. my
go
lords.
and participate with the committees. That will become more easier. A 3-member committee will sit if you have grievance with one person.
Please,
That same order in 13.3 and 4.
please, my lords.
13.3 and 4 same order. Learned counsel for the, you're for? What's your name? Girish Kumar. Learned counsel Sri Girish Kumar
appearing on behalf of the college is present before the court. So also the learned counsel for petitioner. In view of the earlier order in WP 3801 of this court having constituted a committee to verify into the records and the dates of admission of the students to the respondent number 3 college, petitioner as well as respondent number 3 shall appear before the committee in accordance to the order passed today in WP 3801 of 2023 and submit all the details for verification. Yes, madam, same thing you follow.
Please, my lords, I'll do that.
Grateful.
3907, my lords, I will file my objections, my lords, because here,
All right, then I will adjourn it. What's the great urgency in that?
no, my lords, just the
What's
objection.
urgency in 3907?
The only
File your
reason I
objection.
was insisting was because this bench has passed an order previously. If it comes up, they're aware of the submissions made by the respondents, my lords.
All right, relist this matter on 21st. Meanwhile, learned counsel for the respondent 1 and 2 to file objections if any. The memo for withdrawal,
Please. Grateful.
21st. Let's see your conduct.
My lords, I seek for a passover in this matter for 230, my lords.
Yes, where is Abhishek?
Yes,
230.
230. My lords.
Please, my lords. Yes, my lords. We will also be present physically.
Yes, 230.
Please.
Evaluation.
RS4. The RS4 does not have a third evaluation. All right, we list it tomorrow. Notice, who has to take notice? Madam Farah? Madam Farah Fatima? How many respondents? One. Relist this matter tomorrow. Learned counsel for the petitioners present. Learned counsel Srimati Farah Fatima to accept notice for respondent. So I said relist tomorrow. Dismiss for non-prosecution.
Still pending.
Huh? What is pending? Still pending. BPM. What was the office objection that you are not complied? What was the objection? You are not bothered to take also. You don't even know. Purple. Third learned counsel for the petitioner. Orders on IA number 1 and 2. These two applications are filed seeking to condone the delay of 45 days in filing the application to recall the order dated 23/9/2022. The second application on IA number 2 of 22 is filed to recall the order dated 23/9/2022. Now peruse the affidavit annexed to these applications. Reasons assigned and the cause shown therein are satisfactory to condone the delay and also to recall the order dated 23/9/2022, wherein this court dismissed the petition for non-compliance of the office. Objections raised by the office. Accordingly, IA number 1 and 2 are allowed delay of 45 days. It's condoned. And the order dated 23/9/2022 is recalled. The original, the civil petition is restored. Bernard Council to comply with the objections. Within, when will you do it? 2 weeks. Comply with the objections raised by the registry. 2 weeks time is granted to do the same. What is this case, Mr.? This is that bank matter, SARFAESI. Huh? 50 lakhs. What is the amount due now to the bank? No, principal amount. You have gone on some compounded interest which no mathematician can understand. Huh? 42.64 is the principal amount. Sarvana, what happened? What happened?
They are taking some the bank not controlled. They'll take some amount and they'll fix the bank and settle the.
Do they have the necessary source to pay their money? Huh? Banks compounding interest and the credit card companies compounding interest, nobody can understand except. No, I don't know whether you are able to understand the compounding interest. Right now, you accept whatever is coming. You post it. Maybe you can sit with them. When are you going to post? So you are just lifting your hands up. Neither has he borrowed. Sir, we will decide when it comes to the main.
Now we are making, not they are making compliments because as I submitted, not the competition is also less than here. They can consider.
You will go in depression when you borrow such huge amount. And you are given time from past 3 years, you have not paid a single penny.
But now
You obtained an interim order.
Okay,
No, he has offered 50 lakhs. How much are you going to pay?
still works into the bank perspective.
I'm going to record it today. Otherwise, I'm going to.
Lordship may say, no, Lordship may say, 50, Lordship may say, Lordship, 50 lakhs from the including applicants, 50 lakhs from the petitioners. Lordship may record it. Reasonable time may be given. We will deposit that amount and it sits across the bank for the final settlement for the for OTS or some other proposals.
Deposit the amount by tomorrow.
1 week, extent.
All right, 1 week.
Mr. Counsel, 50 lakhs you pay, 50 lakhs he pays within 1 week's time. Then you go. No, then consequences will follow. You cannot keep asking your.
We will inspect, we will inspect them. If someday we will.
That's all. Then we'll allow your pleading application. We'll allow his pleading application.
Because yes.
So he is welcome. What, Mr. Kadapan? What is your good name? Vidhan. Vidhan. So you must welcome your friend who has voluntarily come and got caught in the web. See, in money recovery procedure, we don't know now. He has already said that he has attempted twice unsuccessfully. We don't know.
Not my submission to be recorded.
We don't know. When there is 100 crores, anything can happen. The pleading application is. Huh? The banks have committed suicide by themselves. You are given 2,000, 4,000 crores without any guarantee. What are you talking, sir? You like somebody, you give him without even taking any guarantee. Yes, what has happened in that Bank of Baroda? What has happened to that Mr. Shetty's case? The LOC was issued. He was not allowed to go out of the country. They allowed other people to go when they borrow more than 2,000, 4,000 crores, you allow them. You catch hold of small fish. I remember I was in the bench, we restrained him. Yes. Because you give them loan. No, you means I'm talking about the banks. So Mr. Senior Counsel, 50 lakhs from your client and 50, then you can sit with them and try to arrive at some. But where is the borrower? Right, but that you'll have to also let them know. That you have placed material? Because you cannot have double advantage. Okay, of course, they are jointly and severally liable. But when you recover something from the borrower, you also should let them know.
They never got anything. They came back. They never had anything. Okay, I was surprised that they.
But you did not file any criminal case. What happened?
The banking transaction service before. But they are the legal stand. They are the reason. There's a guarantee.
You have signed.
This is okay. That's what they said. We are not for
No, that you will have to establish in the. But that is quest. No. The proceedings of forgery and fraud.
But as against the bank is still right. They are not hearing the bank is filed by date. That will be.
Yeah, but if you are able to make a case out of the borrower, All right. All right, let's not do it. What is your name? Your name? Bharat. Your file Wakala?
Learned orders on IA. IA number 3 of 2022. This application is filed under Order 1, Rule 10(2) of the Code of Civil Procedure by the impeding applicants, namely Hemant Kumar and Srimati Padma, come on record. In this case, so it is your case that you got a gift deed. As it is a case of the impeding applicants that they have secured this property by virtue of a gift deed. ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ನೀವು? From whom? From Kunjappa. From Sri Kunjappa. By gift deed dated 15/9/2014, which is the subject matter of this writ petition, and also the property, which is the subject matter of the loan amount as a guarantor's property. Stop. I have perused the affidavit annexed to the application. The same requires consideration as bona fide claim is made by the applicants by virtue of a registered gift deed pertaining to the very same property. No, he makes a bona fide claim with regard to the gift deed. His contention that he is by virtue of the gift deed. Hence, I deem it appropriate that the impleading applicants would be proper and necessary party for the adjudication of this list. Therefore, this application deserves to be allowed accordingly. It is allowed. The impleading applicants shall be brought on record as respondents number 4 and 5. Which respondents you will come as? Respondents number 4 and 5. Petitioners shall carry out the necessary correction and make necessary amendments to the petition. File an amended petition by incorporating the name of the respondents 4 and 5, the impleading applicants as respondents 4 and 5 to this petition by serving a copy of the same on the other side. Having heard the learned counsel for the petitioners as well as learned counsel for the respondent and the respondents 4 and 5 is fairly submitted by the learned counsel for petitioner as well as respondent 4 and 5 that they would deposit 50 lakhs each. That is 1 crore in all. Both this court within a period of 15 days, it shall be deposited before this court, and on deposit of such amount, same shall be vested in a nationalized bank. It shall be invested. Which is your bank respondent? But your respondent 1, 2. You have a branch here. be deposited in the respondent, in the Canara Bank of Bangalore branch. The same shall be put in a fixed deposit. Which is the deposit? It's a deposit. Fixed deposit for a period of 6 months, and thereafter it shall be extended for the further period of 6 months until otherwise ordered by the school. It is made clear that the interim order granted by this court that order dated 4/6.
Report was granted on 25/2019. Thus, continued by detailed order dated 4/6/2019.
Order was, what have you said? This court on 28/5/2019 and thereafter on 4/6/2019 would be subject to the deposit by the petitioner and the respondent number 4 and 5 as ordered today. If the same is not deposited within 15 days, the interim order automatically stands vacated. You want me to say that he will approach, not required?
Second week of last week or second week.
This matter in the second week of June. After that, you can take a date of your choice because you are coming from Bombay. Release this matter after vacation at request of counsel for petitioner. Or one copy is not given to you. One, take it. ನೀವು ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ? ಯೋಗೇಶ್ ಅಲ್ಲ? Take a copy from him. Krishna will not hesitate in giving. ಕೊಟ್ಟಿಲ್ಲ ಯಾರಿಗೂ ಶ್ರೀಕಾಂತ್ This is from one district to the other. I think that is not permissible. Page.
Case is squarely covered. This is a legal point now. Point out. Because as of now, this will hold the fort. Even if this is not the ground what they have taken in the annexure impugned order, the fact remains that now you are seeking for transfer from one district to the other place, location to other. How did you go through the vacation? Vacation, let it come up, because I will not have time to deal with this matter. You understand how busy this program is. Several orders to be passed on individual matter waiting. You make a fresh application, they will consider. I list it on 21st. All right, release this matter tomorrow at request your counsel for the petition. No. Documents have you? Where have you filed? The registry. How if it will come so fast? Why it was adjourned urgent to today? Order sheet could. Why it is adjourned to today from? You have filed some documents. Where are those?
And I find one document that was put in the
The ESRBL. When did you file that? Right, though they are not on record, he's also filed something. It is submitted by party in person, Udala Shivaya, that he has filed few documents on 15th March, 15th April. When? 11th of April. On 11th. No, 11th April you filed. 15th March is here. There is some objection in that. 11th April also it is available. That also there are some objections. Attested. There are some objections raised by the registry. You have to comply in the office. Your documents are not here. On 11th April 2023, wherein the registry has raised certain objections, the party in person to comply with the same. General counsel for the respondent, appearing for the Union of India, submits that he has filed few documents today before the registry. They are not before this court on board. Registry to list those documents Take a date after vacation. 23rd May. Court's on vacation from 22nd onwards. 23rd, it's going to reopen on 22nd May.
Yes, sir, even there are means not. What is the job is given? That is not, match for expression, because I acted that is not
See what documents they filed, you can argue all this. Whatever are your expectations and what is the rules of the union. We list this matter on 23rd May. Meanwhile, registry to list all those documents, they sit on board.
And one more thing, they are paying,
And you can't do anything. And first you have to satisfy this court how your petition is maintainable. Secondly, whether they already, if they don't have a methodology for revaluation, then you cannot go in for revaluation. You find it.
inspection of the, whereas name should be act of the what
Maybe inspection, you have to satisfy this court whether there is methodology provided in the rules for revaluation of ESRB. Next. 23rd May. Jagan Mohan. Serial number 3 office of serial number 3 office of kitchen. Appointments for the present. So T Narsipura to Chitradurga. Yes. What is this case? He is unwell, is it in this case? He is unwell. He is all right. Petition. What is the petition you have filed before the civil judge court, Chitradurga? All right. So that is in Chitradurga. What is filed in Narsipura? Restitution of conjugal rights is filed. This petition is allowed. Matrimonial proceedings in MC number 49 of 2018. Pending on the file of Senior Civil Judge JMFC at T Narsipura.
is transferred to senior civil judge and CJ. Chitradurga, is there a family court? Huh? So the senior civil judge handles the family court matters, the designated court. To the concerned family court dealing in matrimonial proceedings. You have already filed this 125 in which court? You are not filed 125. That is filed in? Same court is handling even the divorce matters. I'm seeing. Senior civil judge. Before the senior civil judge, court at Chitradurga. It is the vehement contention of learned counsel for the respondent that this petition is filed only to harass the respondent. And the petitioner has already instituted a petition for domestic violence against the respondent. Which is pending before the JMFC Court of Chitradurga. He further contends that in case this court orders for transfer, respondent may not be insisted on every date of hearing by the valid family judge. Stop. Operative personnel, the learned senior civil judge dealing in the matter, MC 49 of 2018, shall not insist on the appearance of the respondent on every date of hearing unless it is required. The counsel for the petitioner files a memo seeking withdrawal of this petition on the ground that the matter pending before the family court at Bangalore, pending before the family court has been amicably settled between the parties. Placing their submission on the memo on record. Petition is dismissed as withdrawn. Dawat banditala then. Same matter. Says that 163 once posted after vacation. Illa, I can pass order, but it should not be that two immediately after admission it's posted for final year. That should not become a ground for setting aside that. The order is going to be the same, but unfortunately, from the date of admission till now, it's hardly known. I have no interest in your matter. 10th and hardly it will be one week or 10 days. So assumption should not be drawn. No.
So I, in fact, started dictating the order. Or the problem is there is no representation. Representation either I can pass orders even now. Learned Counsel Sri Ravi Shankar CR is present before the court. There is no representation on behalf of respondents. In order to provide one more opportunity, to release this matter immediately after vacation. SLU. Why it was adjourned today? This is the 3 years and 5 years. So you are talking about the coordinate bench judgment. What does she produce? Stopsis is correct, it's available. No, he's talking about some judgment which you are lines. A different student.
The evaluation.
You are not placed that order. You are not placed. There are 6. All right, you have a copy of that order. That's an interim order. All right, you can read what it is. That is after May exam. I have seen it. I have it. In fact, I have marked also what it is. So you are saying there's an order by this court?
Regulation provides that declaration.
Evaluation was conducted. So in the revaluation, you have failed.
Declaration marks for enhanced by 7 marks.
The 17 and 27. Your synopsis. coordinate bench has not passed the final order. ಸಿಂಪಲ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ರೆ ಅವ್ರು ಏನ್ ಆನ್ಸರ್ ಅವ್ರಿಗೆ ನೀವು ಸಿಂಪಲ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ರೆ ನಾವು ಬರ್ದ್ ಬಿಡ್ತೀವಿ ಅವ್ರೇನ್ ಮಾಡ್ಬೇಕು ಶ್ರೀಕಾಂತ್ not in dispute. No, if it is valued by more than one examiner.
Evaluation. It's not change anything but challenge evaluation. Because only revaluation cannot be done if it is valued by more than one examiner.
Evaluation. The further you read, petitioner cannot claim challenge evaluation for us June 21 because his answers have already been valid for twice.
Option is evaluation will not be applicable.
Challenge valuation also is not applicable, is what they have said.
Options for evaluation. Third, they have not given any material.
So what you want to do, you want to argue today on the main matter. Synopsis ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ನಾನು. All that I'll pass out. So anybody else, what about this? Your file? Where is your synopsis, Mr.? In the file, no? ಯಾವ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಅದ್ರಲ್ಲಿ ಇದೆಯಾ? What is the urgency in this? What happens if you don't pass? When is that? No, you already, this is for which year? For which year? Which year of the course of it? Both a previous course. Both science. No. Years course you can complete in 6 years. So how many years? Huh? Correct.
take.
No, why I am asking this is how important, how urgency, because I have to deliver the judgment which are lined up with me based on seniority and urgency. You have completed, your task gets over now. My task begins. So if nothing is much is going to affect, then I can pass it leisurely in the vacation or pursuant to vacation. Nothing will affect you all. So if you pass in this exam, so you have completed the course. So these are backlogs. Synopsis.
Having heard learned counsel for the petitioner and respondent, and the parties having submitted the synopsis, matter is reserved for judgment.
Should I appear for the petitioner?
Yes, which case?
27.
Mari.
Last occasion, you last directed the
Yours is 28.
In the 28 and when
27.
Kumari M. Rajit Kumar Sunge. What is this matter, Mr. Sunge? To issue MBA degree certificate. It's a prayer. Yeah, ಮಾಡಿದಾರೆ course complete ಆಗಿದೆಯಾ? What's the difficulty? File yesterday.
There's no representation on behalf of petitioner. Learned counsel for respondent 1 and 2 are present. Counsel for the respondent number 1 seeks time to file statement of objection, which is ready with them. We shall do so in the registry, serving a copy on the other side. We list this matter after vacation 2023, summer vacation.
Serial number 28.
Anja Reddy.
Will I appear for the petitioner? The petitioner had applied for revaluation for 2 papers, out of which 1 paper was passed. 1 paper he failed. Again, he filed the writ petition, saying that it may be referred to the second revaluator. The Lordship directed the university to produce the rules to that effect. Regulations.
The second evaluator, Mr. Method is there.
Second evaluation. Third page number is the evaluation of answers for undergraduate and postgraduate.
The student is of BE. Mechanical engineering.
Consolidated list for college education initiative. Future detailed hearing. Fourth one, valuation during the re-evaluation should be a single valuation. Fourth, after the re-evaluation, if the difference between the marks awarded evaluation and the re-evaluation. For the 16 and above, then such skills shall be evaluated once again. Not evaluated.
All right.
In
Now,
this case, because the commissioner has obtained the findings, and in the second revaluation, the revaluation is
same.
same. So, the paper cannot be.
Baradilwala, Mr. Nanjareddy,
Well, Ballard,
have you seen the regulation
regulation
notification
yes,
27 September 2013? That is what is applicable to you.
yes,
Is there any other regulation?
Oh, that's not, there are other regulation which is created.
We given him a copy of this. Are you aware of this notification of 27 September 2013?
September 13, it has not yet come September. I think 2020, 13, but I am not aware. Sir.
No, the September 2013,
13.
26 September.
Yes,
Is produced one copy of the regulations.
I will collect
That
it.
regulation, after revaluation, only if there is a difference of marks of 15 and above, more than 15, 16 and above. Only in such conditions, evaluation will be done by one more teacher, the teacher.
Revaluation is done, Lord. Again, second time, Lord, second revaluator I am asking for.
For that, you have to come within that required notification of more than 15 marks. Difference of two evaluators. What have you scored in the first valuation?
The first evaluation I scored, that
25.
25.
Second evaluation, 25.
25.
Okay, where is a difference of 15?
15 is not. Of course, it is not there.
That's all.
That's all.
So now this is
Second,
so which year? Fifth semester.
All the fifth semester, all the subjects have been complete except this subject. That's why I filed this up.
Completed the course, is it?
Completed the course. Now, as a special case, for old students, they have offered a special scheme to write the exam, to enrollment within 25th of this month. That's why I moved it.
So you will get one more chance?
Yes, I will get one more chance.
You can explore them.
Yes. Of course, I have told my student also like that.
One more chance. How many more chances you have?
This, of course, they have given this time. I don't know the next. Okay.
No, by this they would have given you some period.
Yes, earlier also they had given twice.
Huh? ETS, 2016 he should have finished. In 2016 he completed the course, only backlogs. So that
Only back.
there must be some limitations for that also. When? Now, that's the last chance. You have placed that?
21st January 2023, last time I think I furnished the copy. They again one more chance.
Yes, given one more.
Have you placed that material?
Because in previous writ petition, filed by this petition, it was based on the.
So that 4070. Not here. 15293. That is only an interim order. Final order is not there.
In that I declared pass, that only one subject.
Dictionary Obrena.
Obre, sir.
So you had failed in two, but you could clear one and one more is left now.
One more, that for that purpose only I filed this petition. If I had passed,
Okay, that could. I'll dispose it off, sir.
very well, publish.
Third Learned Counsel Shri Ancha Reddy PN for the petitioner and Learned Counsel Santosh Nagarale for respondent number 1. Despite service of notice to respondent number 2, there is no representation this time. Petitioner is before this court seeking a writ of mandamus for a direction to the respondent number 1 university to conduct second revaluation of 5th semester BE Mechanical Engineering for the subject Turbo Machine Paper 10 ME 56. The examination which was conducted on February-March 2022. Stop. It is the case of petitioner that he joined the second respondent college for a bachelor's degree in mechanical engineering during the year 2008. Pursuant to which he completed his first and second year BE examination and passed all the subjects. However, in the third year, he failed in 3 subjects, namely Design of Machine Elements 2, Roman 2, 6th semester, second Dynamics of Machines, third Turbo Machines of 5th semester. This is the contention that because of certain crucial personal problems, the petitioner was suffering from depression.
Petitioner's daughter, sister.
Was suffering from depression, and as a brother he was looking after her, and he was unable to concentrate on his studies, and unfortunately his sister died on 30th September 2022, due to which reason he could not take up the examination for some time. In view of the fact that was not provided an opportunity to take up the examination, we approached this court in writ petition number 4070 of 2022, wherein this court permitted the petitioner to write 3 subjects of 5th and 6th semesters. The petitioner had written 2 subjects of 5th semester, that is, namely, dynamics of machines and turbo machines. And he could not write the subject of the 6th semester, that is, design of machine tools. For the reason that by the time he secured the interim order, the examination time was over for the said subject, and he could not take the exam. It is the case of petitioner that he completed the course during 2014 and 15. Well within time. But certain backlog subjects remained. On declaration of the results for the exams which was taken up by the petitioner, he had failed in both the subjects. However, he applied for revaluation on 18/8/2022, wherein the petitioner passed in one subject, namely dynamics of machine of the 5th semester, whereas he failed in the other subject, namely turbo machine. In view of the petition having failed in the subject of turbo machine, he applied for further re-evaluation by referring the said subject paper to the second evaluator. Wherein evaluator antira, evaluator antira. Evaluator, second evaluator. In view of the reason that the petitioner, after verifying the answers sheet, was of the opinion that he ought to have secured more marks and he had prepared well, which was verified by him from his other professors from different colleges. Petitioner thereafter made a representation to the respondents on 5/1/2023 for re-evaluation by second evaluator for the subject of turbo machines. So the said representation, was it replied and not considered?
Not considered.
The said representation was not considered and neither replied, hence petitioners before this court. Aggrieved by the inaction of the respondent to conduct a second evaluation for the backlog subject, namely turbo machine of the 5th semester. 5th semester allada? 5th semester. It is the contention of learned counsel para for the petitioner that if the second evaluation is conducted, the petitioner would certainly pass in the said subject, as petitioner has got verified his answer script from different professors from other colleges, and they have informed him that he has fared well and he ought to have scored more marks than what is secured by him pursuant to the evaluation, first evaluation. Under these circumstances, he seeks to allow this petition and issue a direction to the respondent to conduct second evaluation
to evaluate his subject paper turbo machine for 5th semester. Full stop. Per contra, learned counsel representing the university vehemently contends that the petition itself is not maintainable for the reason that there is no process of re-evaluation for the second time unless the petitioner meets certain criteria. Full stop. Learned counsel files a memo by furnishing the notification issued by respondent dated 27 September 2013. The regulations governing issue of soft copy and revaluation of answer scripts 2013 within inverted commas. As per the said regulations, Roman para number 6 deals with revaluation of answer scripts for undergraduate and postgraduate students. Subpara I reads as under. One, two, three, four. Subpara ILE 1, 2, 3, 4, 5, 6. I extract all that. It is the vehement contention of learned counsel for the respondent that as per subpara I, clause 5 of para 6 of the regulation, it's clearly evident that valuation during revaluation shall be a single valuation. And after the said revaluation, if there is a difference between the marks awarded in the first valuation and a revaluation, more than 15, that is 16 and above, then the said answer script shall be evaluated once again from a different teacher who had not evaluated the answer script in the first valuation bar revaluation. This being the factual aspect and of the regulation, the petitioner would, if he would be entitled to a relief, he fulfills the requirement of subpara 5 of I of para 6. In the present facts and circumstances of the case, admittedly, petitioner has scored only the, where are the details of that?
Annexure D, Millard, page 19.
Petitioner has scored
25.
25 in the
Turbo machine. 6.
Huh? fail ಅಂತಿದೆಯಲ್ಲ ಅದ
third item, not from
OM ಅಂದ್ರೆ
56, 10 ME 56.
Evaluation. EM ಅಂದ್ರೆ what is next? Internal. So evaluation mark as per annexure D, annexed by the petitioner himself, the marks obtained by him in the for the subject turbo machine of 5th semester, petitioner has scored 25 marks, the original marks, and thereafter the evaluation,
petitioner has again scored 25 marks. ಕಾಣಿಸ್ತಾ ಇದೆಯಲ್ಲ? 25 marks, which is not in dispute. And the internal marks, he has scored 15, and consequently, he has failed for not securing the required marks. In view of the fact that in both original marks and the evaluation marks, he has scored 25 each of the time, and there being no difference of more than 15 as per the regulation stated supra, petitioner would not be entitled for re-evaluation by the second re-evaluator. Hence, this petition does not merit consideration on this simple ground of the regulation not providing scope for second re-evaluation unless there's a difference of more than 15 marks by the original marks and the revaluation marks. For these circumstances, I do not find merit in this petition to allow the application by considering the case of the petitioner. Accordingly, I pass the following order. Petition is dismissed.
That special examination is there now.
Huh?
Notification, special, again, one more special examination has been permitted on 21/1/2003. Liberty to that I can.
So that is why I should deal with that.
Of course. That's minute, of course.
You're right, you can go and take it.
Very well. God bless.
I appear for the respondent, Lordship.
Yes, madam.
Criteria is 40% marks and English plus any other piece. All these petitions are all right.
Criteria for admission to GNM.
Minimum must require 40%. Second is
All together.
any subject, any kind of basic nothing, it should be compulsory.
Lordship,
1 minute. It's better.
Lordship, one submission, Lordship. In this matter, I have to file my objection because the petitioners are admitted for the year 2021, Lordship. So, for they have not agitated their rights for the academic year 2021, that is first year, 21-22, that is second year, now 22-23, third year. Literally, it means petitioner without attending a class or getting the admission approval, Lordship. Now they are before your Lordship and asking for an admission approval and permission, Lordship. I have a serious objection in this matter. They are asking for 3 years permission. It cannot be permitted, Lordship. Matter needs to be heard in detail and I have to file my objection in this matter, Lordship.
Third year now.
Yes.
2021, the admission last date was 18/4/2022. I don't know from where it is. The Land Council has got this.
No, even if you have gotten 22.
22 is my last date here. And the examination, next examination for that year, the student was supposed to write examination for the first time in January 2023. That supplementary exams is happening on 3rd May.
No, you are admitted to the course on 21-22.
The batch is 21-22 batch. The last date for admission was
21-22 batch means you will be coming into this course and the class in 22.
22, man. 18/4/22 was the. I thought they conducted the exam itself in 23 January. Not supplementary. The supplementary is posted on 3rd May.
Always, what are you now seeking interim?
With other students, just 28 students, where my intake is 60, where the college has maintained 28 students were admitted. For the 21 when the registration numbers came after 4-5 months after the constitution. The six petitioners, registration numbers were declared. With no absolutely no reason at all to date for my IPT communication. On a hearsay, they won't give me the shortage of marks. A detailed letter was given along with the marks. Did nothing happened. And their exams commence. The first year's exams commence in January 2023. That exams, unfortunately, they were saying that everyone will be given, and they could not write the
How
exam.
can the exam be in January 23 if you have admitted for 21, 22?
That is what they should answer for that.
You let us hear him. No. Come on to the facts first, whether they are admitted for 21, 22. You are appearing to the college.
Say that not less marks there, at least you may not.
So file your statement. You file your statement. So that we consider when there is no approval, there is a question of that. No. Your admission itself is not approved. Even according to you. Let them,
For that, there should be some reason.
let them give whatever.
This my supplementary exams are either IAM or.
If there is no eligibility for you to write, get into the course, where is the question of writing the supplementary exam?
Documents are.
When is the supplementary exam? When is the exam that you want to take up now? You have to file the statement, you have to hear them, only if they are eligible.
Not a single adjustment.
So you are a college as well. That's fine. So see the document. Why have you refused? Secured by the students, all petitions.
Not in the master.
No, you don't have your marks card.
No, that is with them.
No, you have a copy.
I've written a letter in the system.
Do you produce your copy? You produce it on 21st. Have it on 21st.
His lordship.
The eligibility is there, and if there is some error from your side, we'll permit them to write 1 minute. Permit them to write the examination if they are eligible. Otherwise, no interim order.
Authority. Consider past order.
Lordship, Annexure E, Lordship, petitioner themselves have produced the document saying that their approval has been rejected. Instead of challenging that, they are just asking for a mandamus, Lordship. It is not permitted unless and until the disputed document is set right. How can we proceed with when the facts remains the same and we can give them the permission? Annexure E, page 23. It is produced by the petitioner themselves.
What is annexure E, madam? Not approved.
Lordship, according to them, this is the document which says that whether their admission is approved or not. They themselves are stating, Lordship, there is no clarity in what they want from us, Lordship.
When the students, the details are uploaded into the web, this document can be downloaded. This is happening on 31/3/2022. The last date for approval was 18/4. That means almost 19 days before they had uploaded it. I don't know why my learned friend is making such a completely unrelated. When I download this, the university has, the board has not even raised my document. So by default, the downloading thing in the last column, it will have so not approved.
So
And it is being taken
as
against
on
me.
31/3, it is not approved.
31/3, I just uploaded it.
All right, is it your case after that you have given?
I have uploaded everything there in their web portal where this is allowed here. It does not mention anything. It by default comes not
Sir, please tell the court that your simple case, if you are very qualified and eligible, you should have documents. You place it before them, they will consider it and pass on.
Let me clarify this one.
What is that for clarification?
No, they are saying not.
Sir, you need to address arguments to counter the case of the client, the other side. Address your arguments for the case of your client.
Lordship, one submission, Lordship.
Your case to be decided.
Take the exam.
So now I will dispose of the writ. Your writ is for only for mandamus. First one is for mandamus. Second is again may permit you to permit the examination. Then allot and issue registration number.
Lordship, the allotment of registration number is difficult here. If their admission is
Oh.
not according to
Madam,
the
now the order that will be passed, let them produce those documents, whichever they have, on to show their eligibility. If that is meeting the criteria, then you give them the permission to sit for the exam.
Lordship,
If they are
one
not,
submission. Lordship, one submission, Lordship, there is a cutoff date for submitting the documents, Lordship. And within that cutoff date, petitioners have not submitted it. It literally means that extending the date for submitting the originals for producing the documents, Lordship.
I'm not extending the cutoff date. I'm saying if they have furnished it on time.
Already furnished, yes, Lordship. If they are already furnished, yes, Lordship, we will consider it and we'll pass the orders, Lordship.
Yes. Anything you want to say? Originals are with you. Originals are with you, Madam Sumana Balika.
Lordship, if they have produced the originals, then we will consider it, Lordship. If they have not produced the originals, then it cannot, they cannot be permitted. That is the reason I asked for a short accommodation to ascertain whether the documents are there with us or not.
That's the way it works. Medical students or nursing, these document verification counseling money. Parents also carry them. You know, these entire documents and they will transfer it from council to the board, board to the council. In between, this college document will be given to the other college. This is happening every time. And
Lordship, he cannot make such a allegations, Lordship. If he is having a proper documental evidence, let them produce on the record. In writ petition, there is nothing. Already all these submissions are not permitted. Without permitting us to rebut his statements on the before the court, this is not permitted. That too on the verge of the examination. All these things, what they were doing. If they had a grievance, they could have come before us long back. This is not fair on part of the petitioner's lordship.
Madam, Mana,
Please,
see
Lordship.
now students, petitioners, they say that they have given the originals.
Please,
So
Lordship.
you verify first with your department.
Please, Lordship.
Please.
I have
Your
already conceded to that.
examination board.
Please, Lordship, authority. I am appearing for the authority and I have already conceded that if the documents are with us.
No, no,
already-
no question of if you find out now and submit, I'll list it on 21st.
Please, Lordship.
Because
Please,
now
Lordship.
what happens with these colleges, once the documents are taken, even if you misplace, what the students are going to do?
Lordship, we maintain a log, Lordship, what are the documents
Right, but you
submitted
don't
by
give
the
any
petitioner. I'll
acknowledgement.
verify it and make my submission on 21st, Lordship. No hardship. I'll make my submission.
Things shifted. Earlier it was the council was. But as per the circular, my lord, it says that Vidyarthi Praveshanuvati Prajikarakya Vaisu. It has been shifted to them. This was happening. Because it's the board, because the council, because the board, or it is with them.
All right. Then at council for the respondent number 2.
I appear for Karnataka Nursing Council and the authority, Lordship.
That is respondent number 3. And the first council for respondent number 1 and 3 submits that she will verify as to whether the petitioners have submitted their original documents and as to the date of submitting the original documents. No, I don't think the state is.
It is my lord.
State, why will you do? You are appearing for Diploma in Nursing Examination Board.
Examination board.
Examination Board. So you are there. You would not be receiving any documents. You are only conducting the examination. And 1 and 3 furnish the documents, if any, submitted originals by the petitioners. So also learned counsel for the petitioner to submit if he has deposited the original documents before the required cutoff date as prescribed by the Yaru 1 and 3, na?
Yes, Lordship.
1 and 3, Allah?
Howdo. Howdo.
Then he is also presented.
But the documents are right. In my knowledge, the documents are
Lordship, one submission here, Lordship. I appear for admission approving authorities. So I will ascertain and I'll make my submission before whichever respondents they have produced, Lordship. I can do that much. Any respondents, I'll get the instructions. And if available, I'll try to get the copy also.
Previous test match on 21st. Shuman. Huh? You given him a copy of this? You go through this. So that is this 23-2. You have already filed now a fresh application. Let them consider if that is rejected, you get a fresh cause of action. So I'll post it after vacation.
Or in the meanwhile, if you feel any urgency, you can move the vacation. I am not saying so. Just file it with a memo, madam. Learned Council, Learned AGA files a memo along with the document dated 23/2/2023 for having rejected the request or representation of the petitioner, narrating the reasons therein. Full stop. In view of the same, and petitioner having filed another application representation dated 31/3 is for the respondent to consider the same on merits and in accordance with law. If the petitioner is aggrieved, he is at liberty to challenge the same. Release this matter after vacation. Again, Anushka. Now that they have rejected, you have to first fulfill this criteria. So now your 31/3 will have to be considered by them. What is this, Sumana Balika?
Lordship, this is again a rounding off matter, Lordship. The petitioner is a MBBS student. He has scored first year MBBS. He has scored 94 marks in anatomy, Lordship. Thereby, he failed in that anatomy paper, Lordship. Lordship, kindly turn to annexure B,
Madam, I'll take it
Lordship.
up at 2:30. 2:30.
Please, Lordship. Please, Lordship.
Delay number 31.
Lordship, I appear for the petitioner's lordship. Lordship, in this matter, petitioner is a MBBS student. He has scored 94 marks in anatomy, Lordship. I have stated so in my para 5 of the writ petition, Lordship, page 4. Lordship, as per Annexure D, Lordship, NMC regulations, which governs.
Scored?
Lordship,
How much the petitioner has scored?
94, Lordship.
Where have you stated in para 4 of your?
Para 5, Lordship.
Ah.
Anatomy 1 and anatomy 2. I have made a table and I have written the marks scored by the petitioner.
All right.
Lordship, kindly turn to page 15, Lordship. Annexure D, page 15. Lordship, 11.2.9. In that last one, Lordship, L. This is the NMC regulation which governs the valuation, Lordship. I have produced the relevant portions. Annexure, the L, subclause L. I may be permitted to read, Lordship.
Yes,
The
madam.
the grace marks up to a maximum of 5 marks may be awarded at the discretion of the university to a learner clearing the examination as a whole, but not for a clearing a subject resulting the exemption.
All right. So this grace marks may be granted by the university.
Please, Lordship, that is at the discretion of the university. How they are doing it, they should have to clarify it, Lordship. Now, Lordship, kindly turn to Annexure C, page 13.
Yes.
Lordship, procedure for computation of the results.
Yes.
Lordship, I may be permitted to read. The highest of the total marks awarded by either of the 2 evaluators, that is, best total marks awarded by any of the 2 evaluators for the paper shall be considered for computation of the results. If any decimals occurring during the individual evaluator, total marks awarded by the examiner shall be rounded off to the next higher value for the purpose of computation of the results. The marks awarded and the results so declared shall be final, and under any circumstances, further valuation shall not be entertained and should be made applicable prospectively. Lordship, here, even though NMC has permitted the 5 grace marks, the university has not awarded it. It is at their discretion, Lordship. They are awarding the marks according to their wishes. If it is awarded to me, my marks will be 99, Lordship, and it will come to 49.5 and I'll pass, Lordship. This is all my submission in this case.
So if 5 marks is awarded, you will get 94 plus 5.
99.
How you will pass?
Sir, Lordship, then my average will be 49.5. the average shall
Again,
be,
you get rounded off.
yes, Lordship.
Everything you want grace and rounded off.
Lordship, this is only one case, Lordship. That's all the submission because
All
they
right,
have
now,
got
is
the
the
revaluation.
discretionary? How is this discretion exercised by the university? Who appears to the university?
Girish, Lordship. I've served
He's
a
not
copy
here.
on him.
No, Madam Farah can take.
I have served a copy on him, Lordship, and I have informed him
Oh,
also. Today
were
is
you directed
listed.
to serve copy on him?
Yes, Lordship.
Yeah. Because he's not in the country, I think, or he's gone to Delhi. The yellow gear and all. On the Supreme Court. Argue. All right, we'll tell Farah, Madam Farah to take notice and reply.
Marks have been given.
When?
Why 6 marks? Why not 7? Why not 4? The reading of conclusion.
The discretion that is there with the university, which is a discretion, is not a shall be given, it's a may be given.
After that, again, 1 more mark is being sought.
So that not 1 mark, rounding up.
Then we need to show the scheme of the examination is there. Of 300, 15 plus 40 is 5 will be added. 8 plus 40. And then, from percentage you will have. It cannot be done in this manner. This cannot go on like this. All this has one amount. The round off. In the judgment which has been placed there, we are not parties to the judgment. Round it off. There is Supreme Court judgment which says even a quarter mark cannot be given. Okay.
But this was limited to only COVID or this was open?
We are not, we notice dispensable.
So, madam, you want to rely on the notification of the,
Lordship, I am requesting, Lordship, I am relying on the NMC notification for giving 5 marks, Lordship, grace
Then
marks.
why don't you implead NMC, make him a party?
Lordship, I don't have any grievances against the NMC, Lordship, and it is for the, I don't have any objection to make NMC also as a party. Here, my grievance is against the university, Lordship. If they are giving the marks, there should be a regulation, and I am bound by that. That's all is my prayer, Lordship. I am not asking for enhance the scope of the petition also.
So that could be another way of trying to take out an order from this court. By
Please,
virtue of
Lordship.
this writ petition, you're relying on the notification of NMC to be
Please,
implemented
Lordship.
in the university.
Please,
NMC
Lordship.
says grace marks, which is a
Please, Lordship.
discretion to the university.
Lordship.
Then
Please,
they will have
Lordship.
to scheme whether that order of his lordship, which you are relying here,
Please,
is
Lordship.
open even after the COVID period, or it is only only during the COVID period.
Please, Lordship.
All right, so you implead the party.
Please, Lordship.
How was your discretion exercise? So you have passed in all the subjects.
Yes, Lordship. I have passed in all subjects. And minimum 40 marks, that also I have cleared.
No, if the grace marks 5 are given to the total mark, then if you are able to get passing mark, then that grace mark should be given is what is the guidelines of the what you have relied.
Please, Lordship.
Not for clearing a subject, is for clearing the examination as a whole.
Yes, Lordship.
So now you have cleared the all other subjects.
Please, Lordship.
By virtue of this, you will be passing the examination itself.
Please, Lordship.
But you are still requiring rounding off.
Please, Lordship.
Already
That is where the regulation governing the grace marks will come from the university. How they are giving the grace mark will come, Lordship. University has to inform how they are awarding the grace mark. That's all, Lordship.
But I'll permit you to implement NMC.
Please.
You make NMC a party, then I'll hear all of you and pass.
Please, Lordship.
When do you want it?
Lordship, 2 or 3 days, Lordship, because the exam starts from 26th onwards.
All right, relist on 21st.
Please, Lordship.
Relist on 21st. Meanwhile, counsel for the petitioner to make the NMC a party.
Oblige, Lordship.
Madam, you want an order? Learned Counsel Srimati Farah Fatima to take notice instead of Shri Girish Kumar R as ordered by this court on 12/4. And this is the court. Correspondent number 1.
Please, Lordship.
Correspondent. You also take instruction.
Number 8.
Report. Then Parshuram is also waiting for the same matter. 14 and 8 together, right? So you can also.
The evidence state as a whole on whether they've actually applied to the right with respect to all courses. What does all of the rest of the university regulation from courses? Whether they've applied their mind or not, the case is so there are the complete the judgments also. Then
First team has decided. Right?
It's to internal to external evaluators. Right, I'll record that to place it on.
Fellows, the university is willing to do this. In more than 8 times in RS3.
That is not the case.
can't in fault. He don't spend it. Most of the company what's.
No, sorry, no, that's not the way to behave to your counsel. She's a sister at the bar. You fight the case, not your companion, other friend. You're fighting an issue, Mr. Pat. No, you don't target her. You argue the case. You argue the case or also her. You're not fighting counsels. You're fighting for your client. You're fighting for a cause. Relax. Don't get agitated. I will hear both of you. Yes. So your prayer, Mr. Malipatil, is for RS3 batch valuation of 2+2, right? Eight. So what about 8?
All the documents are in the same region.
But 8 is also same as well.
So as to enable the past candidates as panel previous course to start. First, failed subjects is allowed some of the particular subject. For failed candidates, some of the particular subject also means it's not just it does have the they ask the matter. They refer to as failed candidates only failed subjects. Failed candidates in a particular subject. Because at this point of view, I can see the direction of
With regard to failed subjects. Yes, that I've read it.
but this direction issue also from the other directions.
No, it doesn't make sense calling all those who are passed to come and do it.
Not failing.
No, that is going to become a very big task for the university. No, that is not the order in. That is not the order passed earlier. I have read the order.
First of the order notes next year one notes at the page. So the 51 page 51 of the paragraph number 3.
And then, Justice Devdas's judgment, the exercise shall be restricted to failed students only.
This would be on page 51.
Yes, read it. 51.
However, this judgment shall not any papers in which have already been declared as passed. University allots conducted revaluation of all students and only the fails. They notified for subject wise. For the students who failed a particular subject, only 3 students are. Last subject is not.
All right, that's understood. As they're willing to do.
No, they're saying even the past subjects we conduct revaluation.
Validation, I mean, there will be validation, which respect to the failed students for all the subjects,
Including past.
see, like, they are challenging the ordinance, saying that it is contrary to the ordinance. It's hardly this, get anything.
Yes.
Get anything, but this is the university. Not this, the word, the regulations, when we want the ordinance to be watched, and it goes, what will be the effect of it? If it goes in, then everything has to be the university has taken a call to do it 32 for all the students.
That is
All
your,
the past students will be.
please understand, you want to do a task which is going to involve, no. Court has not asked you to do for the students who have passed.
They'll do it for all the subjects.
Fine.
You don't have different yardsticks.
Where is the yardstick in it?
Get your challenge for the ordinance, you know, benefit of the ordinance.
Now, how it is going to change whether you do for the past subjects?
By grant 20, learning runs 50, the 20 is totally discarded. The 50 is taken.
Oh, that is for you to bring out a legislation, you change it.
They can benefit, additional valuation.
To do what is required to be done, bring out a new ordinance.
At point of time, plus one for every subject.
See, you want to do something university, you can do whatever you want to do. You want to do for all the subjects, for all the people who are not before the court also, you can do. Whoever is agreed, they will come before the court. We'll deal with it when it comes then. Now they are not before the court for past subjects.
Past, election.
Who? That is no longer in dispute. Why are you harping on it?
Who do we have to wait for? Because if that is the judgment of somebody, who do we have to wait for? Do we have to wait for them to sit and decide whether we are going to follow the judgment? That's the waiting. Let us not take the.
All right, you file a memo, whatever you want to do. I will pass an order that you are going to consider this. Any other interim order passed by me earlier in similar? The final order was passed.
They are also.
Then what is your final prayer?
They also must take care of it.
So what is your main prayer in the writ?
They have actually done a lot of right massive points. How they produce in their statement of objections that they have to do the BDS regulations and regulations. They say something else. Ayurveda says something else. Homeopathy says something. They are not copy pasted notes. Other states, neighboring states. For the main prayer. The prayer notes is based on the judgments that are already passed.
Scholars. Only born by 32. So you have nothing to do with all the other things, all the other persons, all the other authorities, all the other disciplines which are governed by the same law. Being a student of 319, only thing that governs in this building is nothing else, including that order. Yes. So,
Say in the university.
ఇప్పుడు నుంచి డ్రాఫ్ట్ ఫిక్స్ ఉంటుంది తెలుసా
Incidentally, not in all the judgments of the previous. Their presence after hearing them, this order limiting it to other supplying. They cannot have an objection. But no, it has to be a. They are themselves party. all the petitions.
We'll allow the application, the implementing application.
I only have to say this, that they will be proper management. Further that needs to be done, like, if NLC has to do anything, if they have a grievance, they may have a grievance against us. They are independent, take action. That need not be done in my regulations. For that reason, they become only proper, but not necessary.
All population. All the students we are basically pressing for that. As far as that. Yes, speak for all. This is half a marks card which has been given. The balance half. Notwithstanding that, the spelling that is done here is 1 marks card. There will be one set of subjects in grade students. One set of subjects will be evaluated. One set of subjects evaluated. If those who have passed evaluated, they managed to pass. Here, grade students, we are now going to take an exercise. Some have passed, some all grade students. Some of them their marks card there will be one set of subjects by 2 evaluators. One set of subjects. Because at least the marks card will be consistent. Of the evaluations. It is a decision. After that, then all say anything for the review. It would be there. It was 32. It will say the distance. Issues of that. The part of it at least is full master.
So in the last year, all the marks are protected. And that question also, I don't say is Jordan is I myself have been done. So both my university, I had raised a very saying it becomes an arbitrary exercise as against saying no, it is a benefit. It does not mean that you are discriminated, you are given 2 additional valuations, you are benefited from it. It does not amount to a discrimination.
In Jordan's case.
That was opposed. Because NLC and university were saying, no, you have to do it for all candidates. It has to be uniform be applied. People would be opposed. Their statement also was not.
But if I remember right, in my judgment, I think I have also quoted Jordan's case. I don't. The Jordan case is relied to conduct 13-2 of 4 evaluators.
We see that first you write down after that to say is
No, now even according to NMC. Even according to NMC, 13-2 has to be implemented. 13-2 is the one that has to be implemented. That is 4 evaluations, 50% external, 50 internal. So erratic evaluation of 15%. So that is what has now been carried out and done. What is the issue now in that?
There is no issue.
They also comment.
Matter of law. There has been some virtue of that. Satisfying not judgment. Not be assessed by four are also wrong. That is why we wanted four. Why? Because or it doesn't or I don't how we can because the balancing factor was required. See, entire exercise number development. Right? You would be that. Just say you have been not changed by two in the as the two person can say, something has happened to you. What have you rather be applied?
So by virtue of 13.2, it is average of
It does not say. It does not say anything about that.
average was 4 was what was ordered by him. Oh no. 13.2 says 2 plus 2, 4 plus 1 deviation valuation. The petitioners wanted average of the best of 2. That was not ordered. You said average of 4 in your case. I think that, no, initially I think Justice Krishna Kumar's order was passed and that went in appeal. Then it came back before me by the division bench chief's court. Then I passed an order. That is now not challenged. So that is holding the fort. That's attained finality. No, in fact, that is what they also want. 13.2.
Revision would be coming. Then revision process. Even the process. That's declared. This process. Makes it University. Going back.
All right, you file your memo to that effect.
What will have to
You file, what is your say on that? Because you are anyway directed by the order earlier passed by me that you will follow 13.2. Because 13.2 guidelines of the GME guideline. That was what was ordered. And I think you are also seeking for the same 13.2.
University, if you get this done, this. Not 1+1 valuation. Itself does revaluation, that is position valuation. Then it would be in compliance with the regulations as well as the judgments must be If they had themselves done it, there was no occasion for me to come and point out the ordinances. For past students will not have the grievance with respect to what the ordinance is. Court also has always said, in all of the occasions, 4 or 5 occasions, when you are doing the exercise, you for the failed subjects or failed subjects only. If they had themselves done it, there is an occasion for me to come. Why are they now trying to twist me by saying, no, I am going to change your results? It is an opportunity for the university. They reopen my answers, ask subjects, answer paper, they are going.
If you file a memo, what you want to do, then I'll pass out this. And tomorrow? So 8 and 14 same. We'll have this tomorrow. Then at the council, Srimati Farah Fatima, representing the university, suggests that she would seek need a weekday's time to file a memo of after obtaining instructions from the university.
Yes, that would be a from the minister. You may have. All for the register to be before your office. So that you will be in a better position to give much.
Particularly orders on IE number 2 for impleading filed by respondents number 1 and 2. This application is filed to implead the respondent number 2, namely Medical Council of India, NMC is a National Medical Council. Huh? NMC, National Medical Council. Leading NMC as respondent number 3. Respondent number 3. I have perused the affidavit filed by the respondent, which is sworn to by an affidavit of the registrar evaluation of the university. The affidavit, the averments at paragraph number 1, 2, 3 and 4 of the affidavit is self-explanatory to the fact that petitioners have sought for implementation of the regulation of 13.2 of the GME regulations 1997. And the respondent having not applied the said regulation of 13.2, and the ordinance is questioned and challenged by the petitioner before this court in this case. Under the circumstances, I am of the opinion that the National Medical Council is a proper and necessary party for effective adjudication of the proceedings in the court. Accordingly, application deserves to be allowed, and if it is allowed, then counsel for the petitioner carry out the necessary amendment, file the amended cost title in this petition. This is only in one petition, or you have filed in all 5? In all 5, just carry out that and file an amended petition thereafter by serving a copy on the other side. Or only amended cost. All other things are not amended, only the cost title, including respondent number. Petition. Respondent 1 and 2 is the university. You add respondent number 3. In your case, what have you done, Mr.
So in this will be applicable in only 14.1, 2, 3, 4, 5, not in 14.6. He's already on record in 14. All right, madam. So you file an affidavit rather. National Medical Commission. National Medical Commission. This learned counsel, the registry to show the name of learned counsel, Shri N. Keti for respondent number 3 in all these matters. The memo ಅಂತ ಹೇಳಿದ್ವಲ್ಲ, learned counsel for the university to file an affidavit by a responsible person. Release this matter tomorrow. 8 hours. 8 also tomorrow. 2:30. Eight ಅಲ್ಲ. Then what is annexure C? For the time being, annexure the production of certified copy of annexure C is dispensed. It's also similar.
To show his name on the application. Notice. Sometimes the notice online ಸೇರಿಸ್ತೀವಿ. Sir, ಆಮೇಲೆ KT doesn't accept it. Show his name in the
Purple, if he is present before the court, is directed to accept notice for R3. One sentence add that.
One which I did for instance. So
Mr. Keti, you have been directed to take notice and your name will be shown for R3.
Body ಯಾವ್ದು? ಎರಡು ನೀವೇ ಬರ್ದ್ರಿ ಕೈಲಿ ಮೂವ್ ಆಯ್ತು. ಆಮೇಲೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಬ್ರಾಂಚ್ಗೆ 2 ವರ್ಷ ಮೇಲೆ ಬ್ರಾಂಚ್ ಏನಾದ್ರು ಬಾಕ್ಸ್ ಅಂದ್ರೆ ಇಲ್ಲೆಲ್ಲ
ಇವತ್ತಾಗಿರೋದು ಕಾಪಿನೇ ಸರ್ವ್ ಮಾಡಿಲ್ವಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ವಲ್ಲ ಅದು ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ಬೇಕಾ ಬೇಡವಾ ಅನ್ನೋದು ಅವ್ರು ನೋಡ್ಬೇಕಲ್ಲ. ಕೊಡಿ. ಅಲ್ಲ ಈಗ ಇದು ಬರೀ ರೀಲಿಸ್ಟ್ ಅಷ್ಟೇ ಸೇರ್ಸೋದಾದ್ರೆ ಸಚಿನ್ಗೆ ಕೊಡೋಣ ಅಂತ, ಅದೇ ಅದಕ್ಕೆ. ಅಥವಾ ಇದನ್ನ ಸೇರ್ಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳೋಣ ಅವರಿಗೆ, ಕೃಷ್ಣನ್ಗೆ. ಅಲ್ಲ ಆರ್ಡರ್ ಆಗಿ ಬರ್ಬೇಕಲ್ಲ. ನೀವ್ ಇವಾಗ ಹೆಂಗ್ ಇವಾಗ ಪರ್ಮಿಷನ್ ತಗೊಂಡ್ರ ಡ್ಯೂರಿಂಗ್ ದ ಕೋರ್ಸ್ ಅಂತ? ಇಲ್ಲ, ಯಾವಾಗಾದ್ರೂ ಬೇಡ, ಆರ್ಡರ್ ಆಗಿ ಬರ್ಬೇಕಲ್ಲ. ಆದ ಆರ್ಡರ್ ಸೈನ್ ಆಗಿ ಬರ್ಬೇಕು. ನೀವ್ ಇದರಿಂದ ಕೋರ್ಸ್ ಆಫ್ ದ ಡೇ ಅಂತ ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ರೆ ಇವತ್ತೇ ಈಗ್ಲೇ ಕೊಡ್ತಾ ಇದ್ದ. ಇವಾಗ ಹೇಳಿಲ್ವಲ್ಲ, ಹೇಳಿದ್ರಾ?